You can trace a lot of these claims back to a couple of initial sketchy studies done by, I believe it was WPATH, and then they trickled down, and all of a sudden you had hundreds of journal articles and doctors basically saying the same thing, that this stuff was safe, but they were all seemed to be relying on a couple of initial sketchy studies. So then if you kind of trace it back to the beginning, my understanding is that the whole house of cards starts to crumble. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. We hope everybody had a good Thanksgiving, and we're happy to now get back at it and talk about some really interesting examples of states suing the government for the common good. So this week we have some good cases. First, we're going to cover an HHS rule that attempts to penalize insurers and doctors that refuse to cover or perform so-called gender transition procedures, as well as some other things, and the continuing litigation efforts against the rule in Florida. Then we'll talk about a new report from the HHS about the damaging nature of sex-rejecting procedures. And we'll end with a discussion on an effort to end Texas's discriminatory prohibition against sectarian or religious participants in a state-funded work-study program. So let's dive into the first one. This one's got a little bit of a complicated legal procedure, but we can get to the bottom of it. It's a really interesting case. So basically, since 2016, several administrations have attempted to implement this rule through HHS, that's Health and Human Services, that would subject both insurers and doctors to criminal and civil penalties if they refuse to cover or perform, depending on who the party is, so-called gender transitions, also maintaining separate spaces for men and women. The idea is basically if you're receiving federal funds, then they're trying to enforce these gender ideology provisions on recipients of federal funds. So this rule went into effect under the Biden administration. I think it was in 2023 it was made final. Is that right, Joseph? Okay. The Trump administration has kind of curbed it. So they've implemented some policies that counteract or stop enforcement of this rule, but it remains a threat to the religious liberty of medical professionals as well as insurers until it is permanently eliminated. I'm going to talk a little bit about that in a minute. So there's been an ongoing fight over this rule in particular, led by the state of Florida with the support of attorneys from ADF. I think I saw Boyd and Gray on there. There were a lot of attorneys and firms helping in this fight against the rule. So last year, a district court granted a stay and a preliminary injunction was put in place, stopping enforcement of this rule pending a final ruling from the court. So with the preliminary injunction in place, the case was still active. The court dismissed the case without notice or request and really without much comment at all. It's an odd ruling, and we'll get into a little bit why that may have happened. But the district court opined in its very short docket entry that a challenge to the rule could not be reheard within any reasonable time frame, that the case was moot, and that therefore it was dismissed. So a lot going on there, but the long and short of it is the state of Florida just recently filed an appeal asking the 11th Circuit to issue a new ruling since the district court improperly dismissed the earlier lawsuit. So the argument, which I think is sound, is that the rule still poses a threat to the First Amendment and unconstitutionally violates the rights of doctors and insurers. So as I had said, first of all, I think this is a great example of the need to get bad laws fully off the books and not rely on short-term solutions, especially not on a current administration's non-enforcement or a current precedent that may keep the bad law at bay, right? We've talked about this at Napa Legal a lot in the context of Blaine amendments, right? There are these Blaine amendments, state constitutional amendments that prohibit funding of sectarian institutions, especially funding of sectarian schools, so religious schools. Most of these Blaine amendments have been held unconstitutional under the line of cases from Trinity Lutheran to Carson v. Macon that we'll discuss in this context later. But we think it's really problematic to rely on things like this, right? Oh, the current administration is friendly to religion and they're not enforcing this. Or, oh, no, we have Supreme Court precedent that makes these provisions unenforceable. Okay, but Administrations change, precedent changes. If you have a bad law on the books that violates the federal constitution, you should get it off the books, right? So I think that's just good practice. We've seen what happens when you don't do this in the wake of the Dobbs versus Jackson women's health case, right? Where all of a sudden, after 49 years of Roe v. Wade being on the books, Roe gets overturned, and all of a sudden these states have old laws about abortion, sometimes 100 plus years old, that are now back in play, and you have to figure out what to do with them. So long story short, if you have a law on the books, you don't think it's enforceable, you don't actually intend to enforce it, you should take it off the books, because times may change and it all of a sudden may come back into play and be relevant. So in this case, again, it's good that we have an HHS that is currently trying to issue policies to counteract this rule, but it remains unacceptable to have federal regulations on the books that are trying to force, in this case, insurers and doctors to perform these so-called gender-affirming care procedures, forcing them to support policies that are contrary to the truth of the human person and of biological sex. Can't have them. And some measures to try to trim the rule back is not sufficient. The rule needs to go. So I'm glad that this lawsuit is receiving some attention, and we're going to talk a little bit about what's going on in the lawsuit itself. But first of all, I just want to highlight, I think it's really good to see these kind of cooperative lawsuits between state officials. In this case, it's Florida. The Florida Attorney General is the filing party. The acting Solicitor General and some of the assistants in those offices are leading the charge on this lawsuit. But you also have appearances from Alliance Defending Freedom, a couple of the attorneys at ADF. I think I mentioned Boyd and Gray. There are a list of other attorneys who are involved. So this kind of cooperation is really important, especially when you are fighting something that has a lot of firepower behind it on the other side, including from the federal government. So state governments, right, AG and SG offices, they bring a lot of resources to these legal battles, right? They have funds, they have attorneys, they have a lot of resources to bring into play in these kind of lawsuits. But then firms like ADF bring specialized legal expertise on certain issues that can really help supplement the fight. So always glad to see these kind of cooperative efforts. So on the merits of this issue, my reading, and I think you'll talk about this a little bit, Joseph, but I think this issue, it's yet another downstream effect of the Bostock logic that I think remains a big problem, right? Because I think at the heart of this is HHS taking the prohibition in the Civil Rights Act of discrimination on the basis of sex and applying it to gender identity, gender stereotypes, gender biases. They use different language throughout in the lawsuit and in the rule. But that's the long and short of it, that there's no prohibition in the Civil Rights Act or anywhere else that's relevant to this case on discrimination on the basis of so-called gender identity, but there is prohibition on the basis of sex. So that's what we're doing. It's another one of these cases, just like what happened in Title VII in Bostock, of bending the meaning of sex, which clearly did not include gender identity when it was passed in the 60s, and bending it far beyond what it can reasonably be said to be doing. So the rule in question here requires funding recipients from the federal government under these programs to, among other things, allow males into private female spaces, provide funding for so-called gender-affirming care, as I said. The district court's original ruling, I think, got it right. Prevented enforcement. It was a preliminary ruling, but it prevented enforcement of the rule because the rule exceeds HHS's authority, right? It goes beyond the statute. It conflicts with 11th Circuit precedent interpreting Title IX. The long and short of it is this is not what these laws say, right? The laws prohibit discrimination on the basis of sex. This is not about discrimination on the basis of sex. This is about an ideology that's trying to force in these controversial so-called sex change or gender transition procedures, which I think, Joseph, you're going to talk about in the next section, as well as like allowing, men in women's spaces and so on. This is not what the statute was meant to prevent. And so for HHS and for federal agencies generally, they can make rules that implement the laws. They can't go beyond that, right? So there's no statute here that gives them the right to make these gender identity rules. And so this rule exceeds HHS's authority. That's the gist of the argument. It's a complicated filing. The appeal to the 11th Circuit is like 80 pages long, But that's the long and short of it. The laws in question, right, Social Security Act as well as Title IX, do not grant HHS the power to declare new civil rights for gender identity. So that's the substance. I won't go into more depth, but the legal posture, the procedure is also quite unusual and we thought was worth highlighting. So Florida got the positive preliminary ruling, right? Then the Trump administration comes into power. From there, instead of entering a final judgment in favor of Florida in this case, right, we had the preliminary injunction, the preliminary enjoining of enforcing this rule from the Florida District Court. So what they could have done is said, okay, this rule is final, right? Final, it's vacated or they're permanently enjoined. You can't enforce this rule. That would have made sense. Instead, what we saw is a final judgment, no final judgment entered, but we see a short, strange docket entry at the district court level saying there is no case or controversy presently pending, and so the case was just closed. So Joseph and I, we were talking about this before we started the recording, but this would make sense if the Trump administration had repealed the final rule, right? If you're fighting over whether this rule can be enforced, whether it can be applied, and then the new administration comes in and repeals the rule, that's right. There's no case or controversy. There's nothing to fight over. You close the case, no problem. But the final rule, while it's been chipped away at, it's still in effect. So I don't understand the unexplained entry that there's no case or controversy presently pending, because there certainly is. The rule is still on the books. So the practical effect, if you close the case but the final rule is still on the books, is the rule is back in effect, at least arguably. The district court also didn't allow the parties to actually argue on the issue of whether this case was indeed moot. So Florida effectively is left without a remedy, right? The rule is back on the books. There's no argument about whether it's moot, about why this was closed. It was just shut down. No party to the case, interestingly, asked for this dismissal. There was no motion filed and ruled on. The court seemed to do this sua sponte. There's no clarifying opinion. There's just this docket entry saying no case or controversy. This is moot. We're closing this case. So again, this leaves Florida without any remedy or proper resolution. So I think the appeal to the 11th Circuit is timely and kind of makes sense. As the appeal brief to the 11th Circuit states, the district court buries this case alive, right? Which I thought was a good way of putting it, right? You can bury a dead case and say there's no more controversy, but this is very much still a live issue. So we'll see what's going to happen. It's particularly a live issue because, as the appeal brief points out, other district courts have vacated at least parts of this final rule. So it's still a hot issue. There's still something going on here. And my hope is that this appeal will do one of two things. One, either alert HHS that this is a live issue in the hope that it'll move that agency to repeal the final rule and put a complete end to this issue, or alternatively to get the 11th Circuit to accept the appeal to open the case back up and actually have the case proceed to its conclusion on the merits in the district court. So, Joseph, anything you want to add on this issue?
Yeah, you mentioned that line where the district court was wrong to bury this case alive, and that's really a great summary of what's going on here. To borrow a line from The Princess Bride, the rule you were talking about is only mostly dead. It is not yet all dead. And it makes me think of, not that the district court is doing this, but it makes me think of this kind of legal gamesmanship, where one party realizes that, oh, like, this isn't going well, we're probably going to lose, let's moot the whole issue so it just doesn't really have this final ruling. For example, in January, the Supreme Court is going to hear Little v. Hecox and West Virginia v. BPJ. Those are the cases about whether or not states can essentially prevent men from competing in women's collegiate sports, right? And in that case, I think Little v. Hecox is the one in Idaho, where the man who wanted to compete in the women's sports and was challenging the ban just said, "Oh, I won't do it anymore. I'll give it up, even though I really want to play, but just because of how this is going, I'm going to let it go." And the ACLU, who I think was representing him, was really pushing to moot the whole case and to just say, let's drop the whole thing because it's not a problem anymore. It is still a problem. All the laws are still in the books, like you were mentioning. Unfortunately, at least as far as I'm aware, the court is still moving forward with the full case. So again, not accusing the district court of that same type of gamesmanship, but it's important to show that when there's a dispute that's still live and is going to impact thousands of people, you can't just say, I don't like what's happening, let's just kind of drop the whole thing and then just moot everything. So with that, we'll move on to our next update, where we'll cover a recent report published by the Department of Health and Human Services that shows the damaging nature of sex-rejecting procedures for minors. As noted by this new report, more and more young people are beginning to either question or feel uncomfortable with their biological sex, or just feel disaligned with it. This condition, as many of our listeners likely know, is commonly called gender dysphoria. If you hear me use that term throughout, that's kind of what I'll be referring to. And some of the numbers here in this increase of kids feeling this is pretty dramatic. There's speculation about what exactly the reason is for this, but per the HHS report, 1 in every 1,000 17-year-olds was receiving cross-sex hormones between 2018 and 2022. So that's when a boy gets lots of estrogen or a girl is given a bunch of testosterone, and 1 in every 1,000 17-year-olds. Further, in March of 2023, there were 271 clinics across the US that offered, quote, medical transition interventions for minors. So we're seeing more and more kids saying, hey, I don't feel like this is right. Lots of different reasons for why that's happening. And then they go to a doctor and ask them to do either a drug or something surgical. And tragically, much of what is becoming the recommended and more mainstream medical practice falls under what's often very grossly misnomered gender affirming care. This is really a term for the very psychological and very tragically often typically surgical and drug-based interventions that prevent and disrupt the standard and healthy biological development of sex-based characteristics. So there has been some opposition to this rapidly increasing practice of these gender-affirming care interventions. But like I mentioned, these procedures are becoming almost mainstream. WPATH, which is the World Professional Association for Transgender Health, they're this pretty big international driver of a lot of these practices becoming more popular. They recommend puberty blockers for kids sometimes as young as 8 or 9 years old, and lots of other similar practices, whether it's puberty blockers, cross-sex hormones, these and the like. These practices are recommended by the Endocrine Society, the American Academy of Pediatrics, the American Medical Association, and many of these guidelines published by these various organizations lack really any serious medical or scientific vigor and fail to follow these processes. So what's happening here is more and more young people struggle with the reality of their sex. And in response, more and more adults in positions of authority and power are saying, change your body physically. So it's so important to have reports like this one from the HHS come up from high-up institutions like the federal government. I'm not going to go through everything in this report because it's over 400 pages. There's a lot of problems going on here, but we'll give some details just to kind of give some picture to what's being described. And this report identifies many of the, again, over 400 pages, so there's very many, of the issues with giving often already depressed and anxious kids puberty blockers, mastectomies, vaginoplasties, and high doses of hormones that are meant for the opposite sex. And among other things, this includes an increased risk of infertility, decreased bone density, cardiovascular disease, any number of other physical ailments, not to mention mental health issues. The report, kind of like I alluded to earlier, also highlighted the general lack of any serious medical rigor exercised in the practice of these procedures. I'll quote directly from the report just because this is one of the more stark findings from it, where it says the, quote, gender-affirming model of care, as practiced in U.S. clinics, is characterized by a child-led process in which comprehensive mental health assessments are often minimized or omitted, and the patient's embodiment goals serve as the primary guide for treatment decisions. In some of the nation's leading pediatric gender clinics, assessments are conducted in a single session lasting 2 hours. So it's saying that they're not following any serious process to make sure these kids can consent, if you can say that a minor can consent to something this drastic and severe, to these procedures. And even when even when there is some requirement for an assessment, 2 hours or less for a life-changing decision. Even further, the report noted the uneven dialogue kind of surrounding this issue and the refusal to listen to critics. Again, quoting from the report, the voices of whistleblowers and detransitioners have played a critical role in drawing public attention to the risks and harms associated with pediatric medical transition. Their concerns have been discounted, dismissed, or ignored by prominent advocates and practitioners of pediatric medical transition. So more kids are having this gender dysphoria condition, and the response is, let me change your body. And then we're ignoring the people that say, hey, maybe this isn't a good idea, even when there's a mountain of medical evidence that there are these very serious mental and physical tragedies that result. So bringing it together, how is this a religious liberty issue, right? Frank always opens our podcast where we discuss religious liberty from the perspective of faith-based nonprofits. Now, we want to discuss this, A, just because I'm motivated by our faith and beliefs. This is a big enough and important enough issue to give it some coverage. And secondly, kind of more related to the specific nature of our work, the lack of medical consensus regarding the safety and efficacy of quote unquote misnomer gender affirming care. That lack often can and does play a key role in lawsuits, both from parents when this is done to their kids without their knowledge and consent, and also from states when they're trying to ban or at least prevent funding for these terrible practices. Recently, last Supreme Court term in Scrimeti, the case where the Supreme Court upheld Tennessee's ban on some of these procedures being done on minors, part of the ruling focused on this exact lack of medical consensus. In the majority opinion, Roberts wrote, "We afford states wide discretion to pass legislation in areas where there is medical and scientific uncertainty." Later on in the opinion, he wrote, "Recent developments only underscore the need for legislative flexibility in this area, and that such uncertainty regarding the safety of these procedures, afford little basis for judicial response." Now, the legal question, like most of our listeners may be aware of in Scrimeti, the legal question there largely focused on due process and whether or not the ban is a sex-based legal classification, but the actual nature of what some call sex-rejecting procedures and their lack of medical consensus played a big part. So it's really important to have reports like this showing, hey, this isn't something that's settled. There are lots of voices saying this is safe, and anyone who says otherwise is crazy. We'll see this come up in Charles v. Salazar, but it's really important for HHS and other reputable institutions to say, no, wait a minute. There are real medical reasons why this is a serious problem. So I would happily remain on my soapbox here for a little bit longer, but Frank, I'll pass it off to hear your thoughts as well.
Thanks. Yeah, I'll start on the religious liberty issue. So for one, it's a religious issue because of what you said, because of what's true, right? If a man is a man and a woman is a woman, and this comes with, created differences that you cannot change by human manipulation, then attempting to change them by human manipulation is dangerous. It's not just that it's sinful, it's that obviously with those sinful decisions come disastrous consequences. So this is a religious issue that ought to be talked about from this angle in the public square. But then the other thing too, and we've said this, I think, from the first episode of this podcast, is that the culture, the secular culture of tolerance quickly becomes a secular culture of compulsion. And so it's very important to fight and make known these things from the beginning, because again, this is not a, hey man, live and let live. If people want to transition their genders, like just leave us alone. As we saw in the last issue, right? Like, because you quickly go from, we're going to allow these so-called gender transitions, to, if you take $1 from the federal government, then you must be complicit in these gender transition issues. It doesn't matter if are you a Catholic hospital, are you a Christian insurance provider, doesn't matter. This is not a matter of tolerance. Religious liberty and the ability of religious persons and organizations to play their role in society is directly threatened by these things, because they are not regimes of plurality and live and let live. They very quickly move to impose these crazy beliefs, whether you agree with them or not. So directly affects religious organizations and religious liberty. The other thing that I just wanted to note is the quote that you read from in the report, I think is really important to remember. The voices of whistleblowers and detransitioners have played a critical role in drawing public attention to the risks and harms associated with pediatric medical transition, right? So as you pointed out, and I read a little bit into this, if you trace back all of the hundreds of supposed medical journal articles, and, I say supposed because there's a lot of strange stuff that happened there. You look at all of the citations supposedly saying that, if you don't transition a kid, they're going to commit suicide, or, this is a safe and effective way to affirm gender identity or treat gender dysphoria. You can trace a lot of these claims back to a couple of initial sketchy studies done by, I believe it was WPATH, and then they trickled down, and all of a sudden you had hundreds of journal articles and doctors basically saying the same thing, that this stuff was safe, but they were all seemed to be relying on a couple of initial sketchy studies. So then if you kind of trace it back to the beginning, my understanding is that the whole house of cards starts to crumble. So, but it hasn't been primarily in the public. There are good doctors and good medical organizations doing good work on this, but like the report says, that what has really blown the whistle and opened this up and made it a public issue that came into play in the 2024 election that is now being weighed in on, as we can see here by HHS, is a lot of public figures in the intellectual world, in the cultural world, in the media, who have pretty bravely highlighted this stuff. This is not Napa Legal endorsing anyone in particular, but I mean, Ryan Anderson published his book a few years ago, When Harry Became Sally, that kind of started to open the door to this kind of conversation of how fast this craziness was moving. I think actually Matt Walsh's documentary at the Daily Wire, What is a Woman, really made this a mainstream issue ahead of the 2024 election. My friend Mary Margaret Olahan wrote a really interesting book called D-Trans, which was a kind of profiling of women who, women who have detransitioned and the harm and the difficulty that they went through in the whole process and how they felt manipulated by the whole industry. So a lot of really good work that brought this, dragged this issue into the public square and questioned this kind of scientific medical narrative that this was unquestioned and good and healthy and all of this. So really important work that has been done, for years. And it was a lot more dangerous to do this work. Now it's a little bit more, if you're mainstream and a conservative or a religious person, you can question these things openly and it's kind of like more acceptable. But 5 years ago, that was not the case, right? It could be a career ender to really speak out against the harm that was being done by the gender transition movement. So hats off to the many friends of Napa Legal and of mine who did the early work of really bringing this into the spotlight. And the last thing I'll say is the media matters, the culture matters, obviously medical and scientific professional work on this matters, legislation and regulation makes a big difference. But ultimately, I've been convinced for years, I've been saying this, that what can end this regime quicker than anything, America is a litigious society, right? You get a couple of 9 and 10 figure lawsuits when you have somebody who's detransitioned, who can prove that they were pushed into this by sloppy medical procedures or lack of procedures, like you had said. Sometimes it's right, one appointment gets you on the track to gender transitioning. If you can prove medical malpractice and the tens of millions of dollars, if not more, in harm, pain, and suffering, as well as medical costs that you're putting these young people through by putting them through this whole transgender procedure mill, I think when the first hospital network or the first medical university gets hit with a lawsuit and a payout that hurts the wallet enough to put them under or put them in jeopardy, then the insurers will say no more of this, and then the other medical institutions will say no more of this, and that's when I think it crumbles. So I know a couple people who have been working on some of these lawsuits, but that's where I'm most interested in watching this, because yeah, you can legislate, yeah, you can shine a spotlight on it through the media, but when you hit medical networks and insurers in the pocketbook really hard and show the damage that this has caused, and a court agrees and awards damages accordingly, I think you might start to see like the most quick, dramatic movements away from this crazy process of gender transitioning medical work.
Yeah, and just to add one last comment there, you had mentioned the concerns about suicide rates and mortality rates among kids that say they have this gender dysphoria. One of the many problems in the response is that if you're going to say, okay, we're just going to then give you a 2-hour assessment call and give you a drug and not address any of your underlying mental health conditions, in what world is that a better remedy than a more comprehensive analysis and help for this kid? So it is a delicate and really sensitive issue, but some of the same voices that are saying, oh, your kid just needs this drug or they're gonna do something terrible, the remedy they offer is careless.
Yeah, no, that's right. There's a lot more we could say on this, but I think we should probably move on to our last issue. I'm sure especially with BBJ and Hecox coming up, I'm sure we'll be covering the gender transition and the women in sport, like these trans issues more in the coming weeks. So let's move on to probably a shorter issue here, though a very interesting one that hits another pet issue at the Napa Legal Institute. So the Texas Attorney General has filed a lawsuit to help protect the religious liberty of job seekers through various work-study programs funded by the state of Texas. And we really like the development. We like the arguments going on here and just wanted to highlight this before we wrap up. So the Texas Higher Education Board has a couple of different programs in play here that help low-income students going into higher ed to find employment through work-study programs, right? So they can gain skills and also earn money to fund their education and set them up for success after school. So this education board provides state funding to potential employers to help pay for part-time jobs whilst low-income students who qualify are in school. But the board excludes sectarian activities. There are two different programs. We'll get into these in a minute. So the Texas Attorney General, Kex Paxton, recently filed a lawsuit against the officials of that Texas board over the prohibition on sectarian or religious activities in the programs. And it's a familiar argument to anybody who is familiar with our work at Napa Legal on the First Amendment and particularly on Blaine amendments. So we're going to just talk a little bit about these programs in particular. So the Texas Work Study programs are partially funded by the state. They allow students to, again, attend and pay for higher education and also get some job skills in the process. This one work study program requires the employment involve only nonpartisan and non-sectarian activities and explicitly excludes those involved in seminary programs or those that lead toward entry into a religious order or religious ministry. And there's also a Texas Innovative Adult Career Education Grant Program that's similar, funds job training and workforce development programs for low-income students, but excludes religious activities such as sectarian worship, instruction, or proselytization. So the program here falls into you'll hear us beating this issue whenever we can, but the typical argument is, right, when you have a generally available program funded by the government, you can't exclude only religious activity or programs, right? It's one thing if you have a targeted program. So in this case, if you had an employment program that says, hey, we're going to help people get into the trades of, right, plumbing, carpentry, and electric work because we have dire needs for those in the state, so we're going to fund those, right? If those funds were not flowing toward people who are doing religious work, okay, right? It's not a generally available program. But when you have a generally available program for work-study opportunities where it's basically all comers, right? If you qualify, if you're a low-income student and you're going to school, we can help fund a part-time job for you in a whole array of types of jobs, but not religious works. This is when you run into clear guidance from the Supreme Court in recent years, right? From Trinity Lutheran to Carson v. Macon especially, the line is clear. The exclusion of religious programs only, and particularly from generally available public programs, it's not required by the Establishment Clause, and therefore it is prohibited by the Free Exercise Clause. The argument to me is pretty simple. I don't want to go over and over it. You've seen it in other places. We've written about this at length. But basically, the Establishment Clause prohibits an establishment of religion. That's clearly not what they're doing. If you had a work-study program that said, you know, Texas is a Baptist-friendly state, and so we're going to fund work-study so that anybody who wants to do work for the Baptist church can get government funds, but Methodists and Catholics and Jews need not apply. Yeah, now we're looking at an Establishment Clause problem, right? Because you're establishing one religion to the exclusion of the others. But just funding religious programs generally is not an Establishment Clause violation in any meaningful sense of what the Establishment Clause is. And so what was said pretty clearly by the Chief Justice in Carson v. Macon is you have this line, right? You can't do things that are violating the Establishment Clause, right? You can't fund works that would violate the Establishment Clause. But if the funding would not violate the Establishment Clause, then prohibiting religion is probably a Free Exercise Clause violation, right? So here, that's exactly what we have. It's not an Establishment Clause violation to include religious jobs in a work-study program. And so what you're doing is basically saying all comers can come to this program. If you're low income and you qualify, you can get a job, but it can't be a religious job. So religious applicants need not apply. And this whole principle of all comers may apply unless they are religious violates the First Amendment. I think it's really as simple as that. We're still seeing this play out in different scenarios, right? We have the Trinity Lutheran case with the program for materials for a religious school's playground. said you can't just exclude religious schools from that generally available program. Carson v. Macon, we have a voucher program. If you're too far away from a public school, you can get vouchers for a private school. Oh, unless you're a religious school, no, we can't do that either. So slowly we're seeing these cases come through and clarify the same principle, that generally available government programs cannot exclude religious programs simply for being religious programs. So always happy to see states finding new ways to chip away at these types of unconstitutional programs, following the law and making it clear that welcoming all types of programs except religious ones, it's unconstitutional, but it's also unacceptable in our society that was rife with Christian programs in all states and across various fields from the very beginning of our history. That's not how our form of government works. We don't exclude religion and then fund everything else.
Yeah, like you mentioned, Frank, we brought up this kind of legal train lots on this podcast. Once a government decides to start a generally available public benefit, whether it's vouchers for private schools, grants for construction projects, partnering with nonprofits to certify parents, tax exemptions for charitable organizations, some of these may sound pretty familiar and timely, they can't say this is for everyone but religious people. And this is, like you said, pretty settled at the Supreme Court for a number of years, but it does come up at the circuit and district level a decent bit. Now, this particular instance does have one little wrinkle that I just want to give a brief moment's notice to. Where the actual claim in the lawsuit itself doesn't get too into the weeds on this point. It just kind of tosses it out as a note. But it does invoke Article 1, Section 6 and 7 of the Texas Constitution. Now, these articles within the Constitution of Texas guarantee freedoms to the religion, guarantee the freedom of worship as well as protections for religious service more broadly. And lots of other, not all, but hopefully not all yet, states have these protections for the free exercise of religion beyond the First Amendment, but they are out there. So it's something that Napa Legal has also zoomed in a bit on. So some states do have these protections that go beyond what the federal Constitution requires. And in cases like this, they can really do a lot of heavy work. So for those interested in seeing how or if their state protects religious liberty to the furthest extent possible, check out your state's constitution, see if something like this is present in it.
Yeah, that's a great point. And also, I would just point out that many states have different constitutional language that protects religious freedom. It doesn't just mirror the First Amendment, but often their state Supreme Courts have interpreted their provisions to say, this provides the same amount of protection as the Free Exercise Clause and no more. So reading the language of the Constitution might not give you the answer, but if you go to the Faith and Freedom Index, Napa Legal's annual religious liberty policy analysis, we do go in depth on this issue. So if you look at the state constitutional protection factor in the Faith and Freedom Index, you'll see there are about 13 states that have some kind of protection for religious exercise that is stronger than what's in the federal First Amendment. So check out the Faith and Freedom Index, see where your state is listed. I will note that the way that we rate the Texas Constitution, it does not currently provide stronger protection, or at least it has not been confirmed to provide stronger protection in the First Amendment. So maybe a case like this would be a helpful way to clarify that and get some stronger language from the state courts in Texas about their own constitution on religious liberty. So great point, Joseph. Thanks for throwing that out there. All right. Well, with that, thank you for joining us for this post-Thanksgiving episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it. If you like the podcast, subscribe to our channel from wherever you're listening. Feel free to support us, napalegalinstitute.org. We always appreciate your donations so that we can continue doing the work that we're doing. We hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious freedom and the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you all.